Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. We had noted in a prior episode of this continuing series on the Idaho versus Kohberger case that the state of Idaho had filed 4 separate motions in limine. This is a pre-trial motion where the party filing the motion, here the state of Idaho, is seeking a court order from the Honorable Stephen J. Hippler to keep certain evidence, information, documents, testimony out of the case. It could be on the grounds of prejudice. It could be on the grounds of irrelevancy. It could be on other grounds. And we have now today learned of what some of these filings have to say, because the motions in limine are now on the court docket. I would definitely recommend, if you have not yet had an opportunity to take a look at the court docket in Idaho versus Kohberger, that you do so. What is the state saying with respect to a very interested to the public and other parties that are following this case, a specific motion in limine having to do with alternative perpetrator evidence? We learned when we noted that this filing was on the case summary page that the state was seeking to prevent Mr. Kohberger from entering evidence regarding alternative perpetrator evidence in the forthcoming jury trial, which will commence, as far as I'm concerned, start of the trial is July 30th, 2025, because that's when voir dire, the process of jury selection, happens. We were hopeful that we would learn some further details once this motion hit the docket as to what specifically the state is looking to have Mr. Kohberger deemed in limine could not present at jury trial. Unfortunately, this appears to be a very generalized filing. It doesn't provide us with any details. For example, is he talking about the BLOOD stain that was noted on the rails heading downward from the second to the first floor at 1122 King Road? Was it something having to do with a possible alternate suspect regarding the glove that was also found with BLOOD on it, which we have just now, as the public, received confirming details from official court records exist? Nope. What the state is basically saying is, look, judge, if you're going to have Mr. Kohberger admit into evidence at the jury trial some alternate perpetrator evidence, he's got to satisfy the rules of evidence, IRE 401, 402, 403, and in support, the state files and points to State versus Meister, where the Idaho Supreme Court indicated that the standard for addressing an admissibility of alternate perpetrator evidence and what it is. There's nothing provided here regarding what alternate perpetrator evidence is the state referring to. It just seems as though these are things that a practicing attorney would need to know, that you have to comply with the rules of evidence and with what the Idaho Supreme Court interprets those rules of evidence to be. So what they say here is, in this case, during the course of investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement, with the exception of information regarding the defendant. None of these tips were substantiated. He's not speaking, however, to the BLOOD stain found on the stairway, which would suggest that someone may have grabbed that stairway rail running out of the property. This is my opinion that I provide pursuant to the First Amendment of the United States Constitution. If you would like to review this motion in limine, please follow the link that I have provided and you can do so. Thanks for joining us here today.